Good evening and welcome to the February 28, 2018 Civil Service Commission meeting. Maybe I roll call, please.
Commissioner Manukian?
Here.
Commissioner Gazarian?
Here.
Commissioner McCarley?
Here.
Commissioner Devine?
Here.
Chair Abkarian?
Here. What's next?
Minutes for the meeting of January 10, 2018.
Move to approve. Second.
Roll call, please.
Commissioner Manukian?
Abstain?
Commissioner Gazarian?
Yes.
Commissioner McCarley?
Yes.
Commissioner Devine?
Yes.
Chair Abkarian?
Yes. What's next?
Oral communications?
There are no cards. What's next?
Recruitment and examination report.
Mr. Doyle.
Mr. Chair, members of the Commission, this is our regular monthly recruitment and examination workload status report showing all of our current recruitment activity. Again, this report lists the various positions that we're conducting recruitment for, whether it's a promotional or open exam, the filing periods, the examination dates, and all the other pertinent information. The list shows 56 active processes distributed amongst staff. If you have any questions about any of these, I'd be happy to try and answer them. Otherwise, this is a note and file item.
Any questions? What's next?
Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, this too is a note and file item. This is our eligible lists that have been established since our last meeting. As you can see, we have created 10 lists, 6 of them promotional, 3 open, and 1 promotional and open. Again, this report shows more or less the process from the total applications received all the way down to the total number that make the list. I'll call to your attention once again on particularly the open recruitments, the high number of applicants we get at the start of it, and then after our somewhat grueling process, or occasionally grueling process, we have a relatively small list, and that's just an indication of more or less the standards that we've set in our employment. So, and if you have questions on this, I'd be happy to try and answer that for you. Otherwise, this too is a note and file item.
Any questions? Mr. Doyle, what's merged on the one before the last? What does that mean, merged?
This is the firefighter recruit / paramedic lateral. It means we've done multiple recruitments for that particular opening, and it was done on a continuous basis. We merged one list with another, and I can have Ms. Hunanian clarify that a little more as she did that recruitment. So,
go ahead.
Mr. Chair, members of the Commission, we basically did a recruitment not too long ago. I believe it was in the spring of 2017. It yielded, can't remember the number of candidates on the list, but what happened was this time around we did have more vacancies, and so we didn't have a sufficient number of candidates left on that list, so we had to do another recruitment and merge those lists together.
Okay. Any other questions? What's next?
Job bulletin for approval. Public Safety Business Coordinator, Police Department.
Mr. Chair, members of the Commission, this is a request to post a bulletin for our police department that modifies the minimum requirements with regard to the experience requirement for a particular position. The position is called Public Safety Business Coordinator, and it would be our intent to post this on a promotional basis, which means it would only be open to candidates currently working for the City of Glendale. This job is going to be handling primarily the financial responsibilities within the police department, such factors as budget preparation, fiscal analysis, overtime analysis, purchasing, long-range financial planning. We feel that we have some really good candidates within the organization to select from. However, there's a bit of a problem with the way this specification was drafted. The specification has 2 components that we're asking the Commission to waive for this particular recruitment. One has to do with requiring a 1-year supervisory requirement, which doesn't seem necessary for this position right now, at least not with to meet the needs of the police department. The other indicates that the experience, 4 years of administrative and fiscal experience would be in a public safety agency, and we've changed that to mean just in a public agency. The idea being we'd truly like to broaden the pool of potential candidates. We'd like to keep this within, but if we kept it as a promotional process within the organization, there'd probably be no candidates who would qualify. And it's one of those situations where we'd prefer to have a broader pool. We think we have candidates sprinkled throughout the organization who might be interested in this move. So that's the main element here. And Interim Chief Povolitis is here if you have questions, as is Sean Chavez, our analyst for the police department.
Any questions? Mr. Gazzari?
If I may ask the chief to indulge us for a moment. Good afternoon, Chief Povolitis. How are you? So I have two questions I'm hoping you can answer. One is the elimination of the supervisory requirement for this process only makes me ask, how many people is this person going to be supervising, or nobody, that we are now saying we don't need any supervisory training or experience? That's one question. The other one, because it is a public safety, the job specification or the subject is a public safety business coordinator for the police department, I'm curious as to who would be qualified as a public, someone who has experience in management of a public safety agency versus a public agency, and what would we be giving up minus that public safety agency component? Are we giving up anything or not? Because police department is a public safety agency, but perhaps the position doesn't require that person to have had the experience in a public safety agency in this position. So I'd like some clarification.
Good evening, Carl Povolitis, Interim Police Chief. Commissioner Gazzarian, let me tackle the first one. We've reorganized a little bit inside the police department, so as we're configured right at this particular moment, the person would not be supervising anybody. We have pooled the office staff under somebody else and are doing some cross-training so that the duties couldn't be there. And I think where we're at right now, this would give an opportunity we can teach the supervision. If I were looking outside the organization for somebody, then I would want the public safety experience, because they then need to understand and learn Glendale's way of doing budgeting. Where I'm at right now is this provides an opportunity to do some longer-term succession planning for our public safety business administrator who handles most of our budgets. But we have a need where we've sort of overloaded that individual. I have a need to have someone do some budgets, do some analysis. The other thing I'd really like to do is grants management, to pull them away, the follow-up on the grants management away from our operational people, where we have sergeants or lieutenants actually trying to manage their individual grants and get those centralized into our business office. And I would look for this person to do that so that our frontline people can do that. So in kind of looking at what we need for this recruitment, I would rather go inside the city with somebody who understands the city's budgeting process, the city's financial process, and has public sector experience. We can teach them the police part. Hypothetically, if we were going outside and they have to learn the inside part, then I need them to understand the public safety agency. And I think, as Matt Doyle was indicating, I think we have some people within the city who would qualify, and a broader pool is always, in my view, better than a smaller pool. And so I'd like to be able to look at those folks for this position.
Just one question. Is this an open or a promotional?
Mr. Chair, it would be promotional, and I should have mentioned this as well. The public safety business series is utilized in both police and fire. So a good question might be, well, if you don't need supervision, why not just change the specification? And we could consider that, but we don't know what the fire department's needs may be, because they utilize this series as well.
Ms. McCarr?
Chief, has there been an occupant of this position?
There has not. This will be a new position for us, and as I said, it's an opportunity that arose as we were reworking last year's budget to build in a little bit of succession planning and try to fill a need and free up our frontline folks to do frontline activities.
And in order to expand the pool, you had redacted the term public safety or
Correct.
term safety
If-
to
if I-
allow you
if-
to
If I looked
recruit
around the
from
organization and required a year's worth of supervision and 4 years of public safety experience, I don't think I'd have anybody who would qualify. And I said, but I think there are people within the city organization who might do a very good job for us.
It's an expansive comment, thank you.
Anyone else? Any questions?
Move to approve?
Second.
Roll call, please.
Commissioner Manukian?
Yes.
Commissioner Gazarian?
Yes.
Commissioner McCarley?
Yes.
Commissioner Devine?
Yes.
Chair Karian.
Yes. What's next?
Review of civil service rules and regulations and discussion of potential amendments.
All right. Anyone has any recommendations or comments on this, or should I just, should I just go
I
one
have-
page at a time and you just go move forward?
Mr. Chair, if you'd like me to give a brief introduction,
Oh, I'm sorry, Matt. Go ahead. Yes, I apologize.
you're stealing my lines here.
I apologize. This is what happens.
Just by way of review, last month, we did have our initial review of the civil service rules, and we had the commission look at mainly the staff-generated ideas and proposals. And I think the commission did a really, really good job going through those. We had a lot of good discussion, and I think on balance, the commission recommended proceeding with 5 of the 9, and the other 4 were rejected. Tonight, we'll be looking at those items that were brought forward by Commissioner Abkarian. He was kind enough to go through the rules sort of page by page and made some comments, suggestions, and some very specific recommendations. And Mr. Chair, I'll leave this up to you, but I would suggest that we perhaps go through this sort of page by page, and we've highlighted those recommendations in red. So I was looking at these prior to the meeting, and it doesn't look like it would be too ambitious to try to tackle this all tonight. So I'd suggest we do our best to get through these. Just a reminder, I did notify the associations of this meeting, this discussion. They're always welcome to come, and they do get the agendas every time. But I have been quite cautious about making sure that they're aware of what's going on. And I did provide them a summary of last month's meeting, and some of them were here and some were not. But for the most part, I think keeping them informed has been an important factor in this. So with that, I'll leave this up to you, Mr. Chair, and we can proceed.
Just an understanding on the process, again, just repeating it. We are going to go ahead and discuss any changes, vote on it, and then the package will go to each association for meet and confer, and then it will come to us with whatever recommendations they might have if we agree or disagree. And then at the end, we will then vote on that final package. So
That's correct.
And then that would go to the city council for their approval.
That's correct. Following tonight, it's meet and confer with the employee groups, and then back to the commission, and then then to the city council.
Is there,
Thank you, Chair Abkarian. I noted in reviewing the materials for this evening's meeting, 24 separate areas where you have made comments or suggestions. My request of you for your consideration is to perhaps take those one at a time and allow my colleagues and I to then have questions if we have, and then we'll proceed. I have questions as to some, but not as to all.
okay,
Thank you.
yeah.
I also have a question, if I may.
Yes.
Just so because I wasn't here that day, I'm trying to get a better understanding. Some of these comments here, for example, it says Commissioner Abkarian recommends no changes to this section, and then next to it, it says opposes staff recommendation. Where is the staff recommendation?
Okay, I think on those items, we talked about those items already, and if you look at before that particular item, there was an actual item that was given to us by Matt.
Exhibit 1.
Exhibit 1. This exhibit already talks about the vote that we had that night on those
Thanks
items.
for waiting, by the way, you guys. I appreciate it. It's very professional of you. But it's okay. Go ahead. So what's the point of going over it again?
No, there were others besides what we had already approved.
Okay, no, I understand, but these reference those?
Yeah.
Okay, so,
So it says staff, we already voted on that item, so we're not, we don't need to really
So we'll-
discuss those items.
Those will go by
Okay.
quickly then.
Yeah. Yeah.
okay, so over and above these, there's other recommendations? Okay,
The ones that, Exhibit A summarizes what
Got
was
it.
reviewed
okay.
in the
So that-
January meeting.
it's already come,
Those
so
are
if
done.
got it, okay, okay.
And
Sorry,
that-
go
some
ahead.
of- Some of what Commissioner Karian is commenting on have already been covered on Exhibit A last month. So
Oh, okay, okay. All right, sorry, go ahead.
If I may clarify, there are, as I said a moment ago, there's 24 items that are redlined. 9 of them pertain to previous recommendations by staff, which, when you were absent, out of an abundance of timeliness, this body proceeded and made recommendations.
Okay.
So it's really 24 less 9 that have
Got
already,
it.
4
So
of
there's
us have
9
chimed
left?
in on.
Okay.
There's 14 left, I
14
think,
left,
based on
okay.
my count.
Got it.
I may be wrong, yeah.
Okay. Then let's go,
Okay, so I will, as I made those notes, I will go first. My first recommendation, which is on page 21 of what we have right now, it was that we actually have as an amendment to the rules, the language of the actual charter itself. We're talking about Civil Service Commission. This way, when we're referring back to the article, somebody could have an amendment right under, and they can actually look at it instead of going to the city or going to a different location to try to see what the language of the actual charter was. So I wanted it to be an addendum to this particular item. So that was one recommendation I had.
And Mr. Chair, if I could interrupt, it is Article Roman numeral 24 of the charter that addresses specifically the provisions for the establishment of civil service and all the parameters that are set there. So
makes a lot of sense.
the recommendation would be to incorporate that somewhere within this document.
I would support that recommendation.
I agree.
I agree too.
Okay, it seems like unanimously everyone agrees. Anyone, any objection? Okay, that's a unanimous approval of that. I will then, the next one that I had
Mr.
here.
Chair.
Yes, I'm sorry.
I would ask the city attorney, do we need to conduct a roll call on each of these items or just by acclamation accept? It would be faster, I think.
Yeah, I think if we had a lengthy discussion on any one item, then we should probably call for a vote on that. But on something like this, where there's clear that there's complete consensus, then at the very end, we will take one complete vote that incorporates all of the different sections that we've talked about. So we'll parse them out. We'll decide as we go.
Okay. On the establishment of the standards, Commission recommends reviewing medical standards. It says the Commission shall establish from time to time by resolution occupational medical standards for city employees specifying the physical and or mental demands of all classifications. Since I've been to the Civil Service Commission, we have never done this. So my recommendation was not to change anything, but at some point, if it says that from time to time we're to establish physical and mental demands of all classifications, that we actually review it based on the language on this particular item.
Mr. Chair, we'd be happy to bring those to you. It's a rather large binder of medical standards. Most of them are very, very old, but still.
I have two recommendations. One, Ms. McCarty, go ahead.
Thank you. I would assume that within that rather large binder, there are standards applicable to the public safety agencies.
That's correct.
Which, again, I would assume would be more strenuous and demanding than the standards imposed upon a clerk working for you, for instance. How many standards do you recall are found in that document?
Commissioner McCarley, speaking broadly, there's essentially, I would say, 3 very broad categories. One being for lack of a better term, the office worker type, the non-arduous. And then the second would be, arduous physical labor. These are our field operations. And then the third would be our public safety.
Yeah, I would recommend, Mr. Chair, that at some point we address that subject as an agenda item.
No, that's what I meant.
think it's within our purview as commissioners. I don't see any necessity of moving forward with the language insertion. rather than
100%.
move forward
That's
on
exactly what I said. I
imperative.
said,
Yeah.
that's in some future meeting, we need to discuss it. My one question that I have about this, now that we have it in front of us, is how, how do we as commission come up with physical and mental demand on classification? How, do we even need this? I mean, my point was to bring it up in the future to discuss, to see if we are qualified to do this.
Mr. Chair, it's quite an old, component of our rules, but I think under the concept that you as a body are ultimately responsible for establishing employment standards for our employees, whether they be the minimum requirements as far as years of experience, whether a college education is required, or the physical standards. And I think that's where it's sort of rooted in. And no, you're not medical people, neither am I, but we have experts, and we have people that we consult with. Every person who's hired by the city does go through some form of a medical evaluation, as I mentioned earlier to Commissioner McCarley, some more arduous than others. But those are, in fact, standards that we utilize, and they exist. And, as I said, I'd be happy to bring those back to you. It's quite lengthy, and for, you have public safety, you have lots of things, vision, hearing. It's quite detailed.
I think Mr. Manukian was first. Go ahead, Mr. Manukian.
I just want to clarify, we're talking about the medical conditions for hiring. We're not talking about workman's comp or things like that, right? Only for the hire. Okay. Got it. Sorry.
And
I think you bring up a good point, Chair Carrion, that we're not really qualified to look at these and say yea or nay. What I would recommend is, before we get that report back for us to look at, that we ask the department heads that control those particular units to review them and tell us whether or not they need to make a change, or, as Mr. Doyle said, they're old, they may be outdated, requirements may have changed. So let them advise this commission that, based on their experience, these changes should be made, these should be added, and then we will evaluate that and make the decision.
Commissioner Devine is going to outlive me. That is my sentiment.
Okay, perfect. Well, then, should we make that recommendation that those standards be reviewed by all department heads, and a future date, those recommendations come back to us instead of us reviewing all of them? Let's do it.
Yeah, I'm trying to think. We're talking about,
This is,
are we qualified? Are they qualified?
Somebody better be qualified.
I suggest,
We have a medical clinic which conducts our pre-placement physicals, and what they do, they look at our job descriptions and we call them, what are they called? Essential functions of each position. And they look at that and more or less determine, okay, this should be this type of a physical, or if it's public safety, it should be this type of physical. There's not a lot of qualitative commentary that I'm not sure a department head could contribute to the discussion.
Then I would amend that suggestion and say, whoever it is that put it together, to look at it and tell us. We want the expert to do it, and you may be right, the department heads may not be the appropriate people to do it. But somebody, as somebody said, somebody put it together originally based on something, and I think that person or that entity should look at it and make the recommendations to this commission.
Commissioner Campazeri.
Department heads are in a unique position, qualified to know the following. The language is exactly from Section 4, subsection A. Occupational, the medical standards for city employment, specifying the physical and/or mental demands of all classifications. Now, I dare say I don't need to be a physician to understand the physical demands of someone working for me in my department, or the mental demands.
The mental demand working for you would be very high.
That would be very high, yes. But because you mentioned, Mr. Doyle, that there's a massive folder, rather old, of all sorts of standards, perhaps medical professionals, mental health professionals, or occupational standards professionals can look at it, and let's see if the city standards are consistent with 2018 standards. Then department heads can kind of cross-check and see if that kind of matches their needs and their personnel. Management associations can chime in, because at the end of the day, if it says the commission shall establish, I view the word shall as mandatory pursuant to certain statutes versus may as permissive. And if from time to time by resolution, well, I suspect that that resolution cannot be had intelligently by this or any other body absent these steps.
So why don't we do this? Let me make a recommendation and see if that would answer your question.
Okay,
Oh,
but
go
I
ahead,
think I should
Sure, go ahead.
refer to the
Go ahead.
standards themselves by indicating that the medical standards and medical examinations have been the source of significant litigation when those standards are applied to applicants who seek positions within a public agency. For instance, it was not that long ago, perhaps longer than I've been around, but within this city and other cities within this metropolis, that the standards for a police officer were male and 6 feet tall. Of course, those were the entry-level standards, the net result of which half of our population was precluded, well, more than half, was precluded and excluded from serving as distinguished members of our police department. Now, over time, those standards have been adjusted, but it is, if we embark upon this endeavor, it is significant, and I incorporate all of your comments because we will at some point be required to seek input from our public employee associations, as well as medical practitioners, as well as those who look at medical standards as a basis for either discrimination or for encouraging diversity. So,
Okay, first of all, the only reason I said what I said was in this particular, because it says commission shall establish from time to time, and for a long time, we had not. So that was my only recommendation. I think we should postpone this for 2 or 3 months down the road, sometime in maybe June, and take a look at, and then bring a report back first to see what is our next step, and then go from there. At that point, we can have a bigger, better discussion on this particular issue, I believe.
if that's a motion, I'll second it.
So I think what I'm hearing you say is that there is concurrence on the part of the commission to bring back a report. This is not a suggested rule amendment, so we can strike the comment from here, but staff is taking your direction to bring back a report at a later time.
There's no striking of it. It says bring back in a future meeting to
Right.
discuss this, which is what we're doing.
So this is not a exactly. So
No,
we're
there was
gonna-
never a proposal
yeah, so
for
we're
a
just-
change on this, in this section at all.
Right,
From the beginning, it wasn't.
right.
It was just a recommendation that we bring it in a future meeting, which is what we're recommending now.
What would we accomplish in a future meeting that we couldn't accomplish now by having them start the survey or report with the appropriate agencies?
But that's what you're doing, is that you've provided direction. By the discussion here, we understand there's enough interest on the part of the commission to receive a report at a future date that hears about, that studies this particular item and follows through on the mandate of the rule to hear from time to time on the standards of the medical requirements. Did I misunderstand your
Commissioner
point?
Devine, my issue is, I don't know what the process is to go from point A to point B. First, I want to understand the process, and then make a recommendation as to what report we would need from them. But not knowing what it takes to have a recommendation for a physical or mental agility, not understanding that process, I don't know what report to ask.
Mr.
Or
Chair.
maybe, if you do, please ask for it, and I would.
Okay, I thought I had asked for it, maybe it wasn't clear,
I
but...
thought so too.
Okay, so ask for it, and then we'll have it scheduled for a future meeting.
Okay, and I agree, it's going to be down the road, it's not
Yeah,
going to
go
be
ahead,
next week.
please.
But what I was suggesting was that staff put together a report using either the department heads, either or the department heads, and the entities that Mr. Doyle mentioned that really put the qualifications together, the professional in the healthcare, and put together a report that includes their comments, the professional comments, the department head's comments, and come back with and that report will come back with recommendations to this commission for making changes to the requirements.
I would second that.
Okay. Is there any objection to having that show up in a future meeting?
No.
No. Okay, so that's a direction to
Mr. Doyle has
and his
a
staff to
quizzical
bring that
look on his
report in.
face, and I'm wondering, am I asking for something that's impossible to do or to
No, Mr. Chair, Commissioner
Nothing
Ryan.
is impossible, Mr. Doyle.
Nothing's impossible, yes. No, I just thinking about it, and again, I'm trying to figure out what would be most meaningful for the commission's benefit, but, I could foresee just maybe a summary report on how we do it, what the steps are, and where these standards are derived. Some of them are, Cal OSHA, some of them are POST, some are NFPA, which is the National Fire Protection, and maybe walk the commission through that process, and then if there's further direction on the matter, we can take further direction. But this is a topic I can't recall us ever discussing or addressing for a long time.
Yeah, it's been,
And I think
from
we'd be
time to time, we are to discuss it, though.
Time to time, yes. So,
I think what-
Commissioner Mnuchin.
I think what Commissioner Devine is saying is he wants to see if those standards that are in this century's standards, similar to, how do we know they're,
I think,
that's what,
I think Commissioner Devine was very clear as to what kind of
Yeah.
report we need. I think,
What I'm hearing, what I'm hearing are two different methods of solving this problem. One is what I'm calling an interim step that Mr. Doyle is suggesting, and perhaps some of my colleagues, where before we actually have the report with the recommendations, we have a report that tells us how to proceed with the recommendations. And then once we get that, then we'll discuss it and decide whether we want to proceed. My feeling is, and I agree with Mr. Abkarian's first premise that we need to look at it, why bother with this initial step? Mr. Doyle outlined, the different entities to deal with, the POST, and I forget all of the ones you mentioned. Why not just have them go ahead and do the process and come back with a recommendation from all these entities and the department heads
for any changes.
for any
necessary
changes
for it.
that they feel should be made, and not have to have another meeting where we're going to sit here, have this similar discussion and say, well, go ahead and do it.
that's fine, that'll work.
That's what we need. That's the report we need, Mr. Devine. So the staff will give us that report after they have discussions with all department heads, and
Can
they'll.
that be
they'll
done next week or 2 weeks?
It'll be sometime in the future.
Okay. We need to take a vote on that, Ms. Barpetti?
No, we don't. I think it was, everyone is pretty much. Next, I want to go ahead and just take out the next one, which was 4D, unless if someone has any other comments on that.
I'm sorry, say that again.
4D, I'm going to be addressing that in some other process in the future, so I'm going to take that one out.
Okay.
Okay.
So we strike the
next one
comment there.
is- Yeah, next two, I'm just trying to understand if there's a rehab transfer or medical transfer, if the employee doesn't agree with it, do they have a right to appeal to Civil Service Commission on both of those? And actually, that also applies to the medical exam reevaluation.
Absolutely. Mr. Chair, members of the commission, on certainly any medical issue that should arise, whether it's a physical exam or even in our public safety, we do psychological exams. If there's any failing of that and appeals, they would ultimately be brought before this commission. The item E and F on page 29, rehabilitation transfers and medical transfers, they're a little bit of a different circumstance. And to answer your question, Commissioner Abkarian, is this appealable to the commission? I would say anything relating to the placement of employees in positions would be something that an employee could bring before the commission. I do want to point out, however, is that on the rehab transfers and the medical transfers, they're both very similar circumstances. And this is essentially when an employee, an existing employee, is found to be restricted from performing some components of their job due to a medical issue. And this happens, I don't want to say with great frequency, but it does occur.
And who makes that determination? The city does, or their employee's doctor does?
It's a medical call. It's not the
Medical call of the city doctor or the employee's doctor?
in a rehab transfer, it will be a workers' compensation doctor. On a medical transfer, those are typically non-work related medical incidents. If somebody is out water skiing or something like that, and they get paralyzed or something like that, we have the same obligation, and this is really this is beyond just the commission. This is Americans with Disabilities Act, which is federal law, and the California Fair Employment and Housing Act, FEHA. We have obligations to address these employees and the necessary accommodations should they become disabled or sustain medical restrictions that would prevent them from performing the essential functions of their job.
Let me ask you a question. Still, I don't mean to cut you off. I just want to get to really the bottom reason of what I put that in here. I just don't want there to be a manager who doesn't like an employee, who basically somehow, it will never happen with you, but 50 years down the road, it is in cahoots with some medical professional that works for the city, and they basically transfer this employee because this manager doesn't like this employee. And they call it a medical transfer, and then the employee doesn't have any right to appeal that decision by the management because they're being transferred from medical transfer. That was the reason that I said, is there a right for an employee to appeal that decision if they believe that their medical transfer is improper?
I would say yes at the end of all that, but I will say it's a very substantial process that we undertake when this does occur. Under the Fair Employment and Housing Act of the state of California, we are obligated to go through a process known as the interactive, and I'm sure some of you have heard of that. And what this means is the city doesn't just get to decide, oh, this person can't do the job anymore. The city has to meet with this person and their representatives, if applicable, and sit down with them in a conference room and listen to their ideas, their suggestions for whether or not we can accommodate them. So if somebody ends up with a significant back injury where they can no longer perform maintenance work, and in most cases that would prevent them from performing the essential functions of their job, we would notice that employee and we would say, hey, it's our obligation now to engage in the interactive process. We're going to set up a meeting, and my staff, my employee health staff, and the department supervision sits down in a meeting, and we have to engage ideas and suggestions on whether or not that work restriction can be accommodated. And I will say, in probably 9 times out of 10, we are able to accommodate whatever work restriction somebody has, whether that be the assignment of certain arduous tasks to other staff members, or making some type of a change to the work environment which would enable that person to do jobs utilizing, instead of lifting 50-pound sack of cement, we could use a forklift to lift that, those types of things. And that's what we're obligated to do. We do probably a dozen of these interactive meetings each year. And it's a very rare circumstance where we get through this process and we determine, there's just nothing we can do to accommodate that employee. But I want to underscore how important it is. Disability law is probably one of the biggest areas of litigation right now in the employment law field, and something we take very, very seriously, and we allocate a lot of resources to it. But we go through this process regularly, and I will say in most cases we are able to effectuate some type of an accommodation where that employee is able to do their job or another job, which and that gets to the substance of a rehabilitation transfer, medical transfer, if we have somebody in an arduous position, maybe they're an electrical line mechanic, and they can't climb anymore, and it's clear that they can't climb anymore, we might find a place for them in the engineering department where they might sit at a desk and do drafting work or something along those lines.
I understand that, but again,
That's-
if they're transferred and they disagree with it, they can appeal to the Civil Service Commission, correct?
Yes.
Okay.
Mr. Commissioner?
I'll wait.
I was just going to say, and I agree, I think the point that Mr. Abkarian makes is right on. The only thing I would say is that we need to add that one sentence in.
That's it, that's all I'm
these two
asking.
things that, you know, it talks about the city manager and talks about the department heads being in on these decisions, and Mr. Doyle explained very well how the process works, but I'd like to see, and I'm sure that's what Chair Abkarian is saying, is put one more sentence in there and saying the employee has a right to appeal to the Civil Service Commission, period.
The decision could be appealed to the Civil Service.
Would it, just on, I'm sorry, just to that point, would it be appropriate to plug that in Section 7 where it talks about the appeal, and yet it's specific to disqualification, to say that it would be an appeal for disqualification or transfer?
If I may, Ms. Varvettian, because I'm going to tie those together. This is what I'm having an issue with. When we look at rehabilitation transfer, subsection E, and we look at subsection F, medical transfer, what's glaringly present in one and absent in the other, and then subsection 7 seems to then talk about it, but doesn't really make it uniform or make it clear that it's uniform. Rehabilitation transfer is one where the city manager, with the concurrence of the employee. So that almost tells me that the employee is concurring, that infers that if the employee does not concur, the employee ought to be able to come and seek a second opinion, if you will, from this body. Whereas the medical transfer, it talks about the appointing authority may, in accordance with law, which is comforting, and with the approval, doesn't say with, but with the approval of the city manager, transfer the employee, but does not really put in there that that's necessarily also with the concurrence of the employee. So it could be without the concurrence of the employee if I'm to read verbatim that subsection. Now, as Ms. Varvettian was pointing out, and I don't know if she was going there, I think she was perhaps, Section 7, appeal of disqualification, talks about an applicant or eligible. And it took me a while to kind of figure out, what does that mean, an applicant or eligible? That means what, somebody eligible?
That's correct.
Yeah, okay.
It's a non-employee.
Right.
At that point.
So that could be an employee or a non-employee. Is that what we're saying? Because
Or someone who's eligible to be employed but has
to be
not an
employed but has
now.
been disqualified because of all the grounds for disqualification that are in subsection C of section 6. There, it says the commission shall review and consider the appeal and render a final decision on the matter within 30 working days after the conclusion of the hearing. And it's loaded with the applicant or the eligible shall be entitled to appear before the commission, to present his or her case, et cetera, et cetera. So unless we're going to put in every one of these things, subsection E, rehabilitation transfer, subsection F, medical transfer, that these are with the retention of an aggrieved or an affected party to seek remedy or redress, or we can refer it all to, these are subject to section 7 procedures.
We could say, as set forth in Section 7,
Yep.
the appeal,
Commissioner Menendez.
Just wanted to make a comment. It's always been my understanding on this commission that these transfers have always been with the employee's consent. And if the employee does not agree, they can appeal. That's always been my understanding. And I think it doesn't hurt to make sure it's covered in here that all of these are according to, if the employee does not agree, they have a right to appeal. Because if we don't put it in there, sometimes it
Gets forgotten 10 years from now. We're not here. This body's not here. Mr. Doyle isn't here.
oh, I'm going to be here.
Ms. Nanya, and then we basically at that point, an employee comes and says, do I have a right to appeal? And now they
Yes.
have to restart this entire discussion, do they have a right to appeal or not?
So I guess the question for us I'm hearing concurrence that there should be some mention of one's ability to file an appeal.
Correct.
Is
If
there
they
a
don't agree.
preference as to whether or not, I'm sorry?
If the employee doesn't agree, or
Right. I mean, certainly that's part of the process. I think the question is, should it be included in the rules or not? Is there a preference as to whether it should appear in sections E and F or in the catch-all section that talks about appeals?
I would suggest in the catch-all section to economize on verbiage and make reference to the appeal process as outlined in the catch-all section, section 7.
Commissioner Bryant.
I would agree with that, with one exception that, and again, they could, so, I'm not an attorney, so, you know,
That's
it's a play
good,
of words.
that's good, you probably know more than me.
Okay, no, the thing that I find troublesome with that is that we're talking about a terminology called rehabilitation transfer and medical transfer. Nothing in there mentions the word disqualification. When we turn to section 6, where it talks about disqualifications, and then we look at 7, which it calls appeal of disqualifications to a layperson without going to a federal judge, I have a hard time connecting those two together. So to make it simple, and I think Ms. Varpetian hit the nail on the head, let's put the wording into section E and F, again, as Mr. Abkarian just originally suggested, put in some verbiage in there that if the employee does not concur, there's a right to appeal to the commission. And that way, we don't have to interpret whether disqualifications and appeal of disqualifications applies to rehabilitation transfers and medical transfers.
I agree.
That's my 2 cents.
For the record, though, Section 6 disqualifications has 3 sections. A is disqualification before appointment, B is disqualification after appointment, and when you look at C, grounds for disqualifications, subsection 4 is essentially rehabilitation transfer and medical transfer and beyond, because it talks about a determination has been made that the candidate cannot meet the essential functions of the classification for which he or she has applied with or without accommodation. Now, that is a candidate, but B talks about an employee may be removed from position after appointment in accordance with provisions, and the only provision that would apply for the medical and rehabilitative transfer is a determination in subsection C4. So it is, as you've suggested, Commissioner DeWine, it is one that requires a great deal of
Interpretation.
experience in reading and interpreting and tying in different paragraphs. So with that concern in mind, I would make it certain that there's a tie-in in these subsections, that all reservation of rights of appeal are still.
And you brought up an excellent point, Commissioner Gazarian, that in section C4, they use the word candidate, and here in the transfers and the medical and rehab transfers, they're talking about employees, not candidates,
Right.
Which is what.
And that's the only one that comes close to
Yeah.
it.
So-
The other ones are all other misconduct.
So
type,
again, I would say to wrap this one up,
Yep, let's go ahead and include a language that says that if the employee doesn't agree, that there will be a right to appeal to the civil service.
in sections E and F.
DNF.
ENF.
ENF, ENF. Any other comments?
I think we should have a title right at the beginning. It says, everything in this book can be appealed to the civil service.
Well, not everything can
If you
can be,
disagree,
but-
if you
Yeah,
disagree.
right. If you disagree, appeal, and then we'll decide if it's appealable or not.
Just a coda
Sure, go ahead.
that suggestion, as I was considering the entirety of the document, it would require major surgery or insertion of a particular section addressing appeals and those actions with respect to our employees and/or candidates, and that process, what allows those individuals in the status that they present themselves to have the opportunity to reach our level for determination. But that's major surgery on the
Yeah.
document.
Yeah, just for example, merit steps, if it's denied, even though somebody is satisfactory, that's not appealable to the Civil Service Commission, I'm told. And I always thought that it was. So, I mean, we can always bring some specific issues as to what's appealable, what's not in a future date. Let's do the rules, and then we can add to them at some future point, anytime, any item we would like. Mr. McCarley? Commissioner McCarley, you're good?
Let me say, Mr. Chair, again, this is, I realize reading this may be a little confusing, and I assure you, I didn't write this. It was written long before I got here. But
Mr. Doyle, I'm sure you engineered this whole thing to fit your needs, and so you can manipulate the entire system.
Sure.
That is saying, I'm saying a joke. I'm sure somebody transcribes this. So we'll
Yeah, please.
the point I was trying to make was that, my reading of it is that these would apply to applicants and employees. And I will say, since these rules, have been in effect, which has been for many, many years, the state of the law relative to disability discrimination and the obligation to accommodate has really, really changed, particularly in the last 20, 25 years relative when the Americans with Disabilities came into effect. But I will say, under the law, there's really no difference in the way that we treat either an applicant or a city employee who faces some type of a barrier due to a disability or a work restriction. We would treat them the same way. This interactive process that I addressed, it has to be applied to applicants as well as to employees. A lot of people don't realize that. But if we do hire a great candidate who goes through, gets their physical, and they're found to have some type of a congenital problem or medical issue, we have to go through the same interactive process and the same consideration of accommodations as we would of a city employee who's been with us for 35 years. So the state of the law has really changed.
we appreciate that comment. Thank you. Can we move on? We're all good? Okay. My next recommendation was when we go to the medical evaluation and the health department on section E, page 32, the health services decide, oops, we have gone through this and we made a mistake, and we're going to, or either a mistake or we're going to withdraw our, what is it?
The disqualification.
Disqualification, sorry, my brain just went blank.
That's okay.
At that point, the employee has gone through the process, when the employee has gone to a medical evaluation on their own, with their own expense. They've gone through all of this, and then based on that report, there's a decision that this disqualification will be set aside. I think the employee should be then reimbursed for their medical expenses of spending that money and going through that outside independent examiner.
I may?
Go ahead.
And to really elaborate on Chair Abkarian's suggestion, I draw my colleagues' attention to Section 8, subparagraph B on page 31. Because there it states that the eligible shall then obtain at his or her own expense an independent medical examination report on the areas in which he or she was disqualified. So I appreciate you paying a great deal of attention to that, Chair Abkarian, because that makes me then understand. Because when I looked at the red line and I said, and be reimbursed reasonable medical expenses, wait, it sounded to me at the outset as though we're penalizing whatever individual or the city by extension for disqualifying someone who then is deemed to be really not disqualified, and then it was an error. I would have been less inclined to be supportive of your suggestion had I not gone back, and I spent quite a bit of time on this, and realized that, wait a minute, if we're going to make someone pay out of pocket to make us, the city, or whatever entity it was, whether it was the appointing authority or a department head, to see that, no, I'm not really disqualified, then perhaps that is a fair provision there, that a reasonable expense that has been incurred to correct an error that has taken place to be reimbursed.
Certainly, I want to express concern and sympathy for the candidates who have faced disqualification on medical grounds. And when we look at the particular provision that has been highlighted by our chair that addresses applicants, candidates for positions within our great city, I would suggest that my comments, which I'll give in just the next 20 seconds, would not apply if the issue related to reimbursement of our city employees, which stand, at least in my perspective, at a significantly higher plateau than a candidate. But when you talk about reimbursement, that becomes a fiscal issue. The extent of that fiscal issue, I have no idea. I would submit that we need a little bit of statistical data to tell us the number of individuals who have sought independently a review of the disqualification with a medical practitioner. And then we have to look at the costs, what those costs for an equivalent medical examination, which would be appropriate. I think those medical examiners in another provision of this document have to be approved by our department, I think the HR department. What the cost, is it $1,000, is it $5,000, and what that cost does to, and I suspect it would come out of the HR budget, what that would do with respect to Matt's budget within this city. I also will say that in my experience, whether limited or broad, that reimbursement of a candidate for independent medical examination, I have not seen that. On the federal level, I've not seen that. This is treading new ground. It might be an advance in employee relations, although once again, I turn around and say my primary support is with the employee. Candidates haven't yet reached that level of protection. That's my opinion.
Well, I appreciate your input and I value it, and I cannot say I disagree with your concerns. I would want to point out that perhaps as it relates to employees, those who have a vested property right in their employment,
That's good.
that if they are deemed to be medically disqualified, perhaps a provision should be made available for them to seek a second opinion at city cost, but if that second opinion is consistent with the initial disqualification, then they ought to bear the cost of that, perhaps.
May I incorporate that in my comments as well, because you address city employees, active city employees.
Right.
I'm fine with that.
Can I-
Protecting
can
the
I-
employee.
Can I make two comments? And it relates to it. First of all, if you do it the way you just mentioned it, then the city is going to be a collection agency running after
I know.
employees trying to collect
I know.
money, which would be a nightmare because I know where this could go. The second is an employee or a candidate, an applicant, let's say for the police department, is being disqualified by the health department of the city for some reason, saying that they're not psychologically qualified to get this job. Let's say a police officer. I'm just giving you an example. Or
An
an employee.
employee or an applicant?
An applicant who's passed every single test, and the last step for them is to basically go to a medical exam for them to be able to get the job.
Okay.
Now, the medical, they've passed everything. They got 99% on all the tests. The final step is for them, I think for police officers, they have to go to a psychological evaluation.
There is.
Okay, so they go to the psychological evaluation and said, you're not qualified now. The employee says, wait a minute, there's nothing wrong with me. This guy just doesn't want me to get into the police department. So at that point, and I'm just bringing police department because it's a bad example, but just an
No,
example
it's a
of
good
it.
example, because
Okay,
this is probably
because
the most common
The most common on the
circumstance
police
of this.
example.
We've had an appeal.
So you do a psychological exam, so you ask him, now you go and get your own evaluation now. So he's an applicant, he hasn't gotten a job, but he has a 99 on all of his tests, he's qualified to get the job tomorrow. And he's passed everything. So now he goes and he gets an evaluation by an outside examiner, a psych guy who is approved by the city based on his qualification, and comes back and says, this guy is 100% qualified to get this job. Then you take that to the health services looks at it and said, this is pretty good. This report makes sense. Accordingly, what we said to you, we're gonna go ahead and reverse now. And the applicant could get the job now and become a police officer in the city of Glendale. Now, that applicant should be reimbursed because they went through all this expense. They're not employed, they're applicant, but they had qualified, taken all the tests, and the last step, they've gone through investigation background, they've gone through everything else and qualified. Tomorrow they get the job minus this medical exam. And now they've gone through all this, they should be reimbursed if the job is being given back to them, basically. And they made a mistake.
They shouldn't, and I'll tell you why. Because this reminds me of civil practice, which I used to practice 25 years ago. You'll have a city expert, a medical professional who says this person is medically not qualified. Then the applicant, in your hypothetical, will go seek an applicant expert that will say the applicant is qualified.
Right.
If you are going to impute financial responsibility on the city, should the city then go with the applicant's expert?
No. You're missing one step. The second step is that report has to be turned into the health services of the city.
And they change their position.
The employee health services then change their position and says,
Right.
we are now going to go with the applicant.
Right.
We agree, and we're reversing our position.
Right. That is exactly the hypothetical I'm going with.
And we had an appeal, by the way, but just about this
Yeah,
scenario.
If I may finish my
I had
hypothetical.
a case exactly like this. This is why I'm going with this. Okay, go ahead.
Okay, so the city health department
Reviews both of them and
Right.
just makes a decision that we made a mistake. We're reversing our decision, disqualifying this individual.
Right, so if the city health department reverses its decision, knowing that the city will then reimburse
Of
for
course,
that cost,
Of course.
in my mind of suspicion and paranoia, you know what it takes me? It takes me to a place where the city health department may decide not to agree with that because that's going to cost the city money and fiscal issues as my colleague raised moments ago. And I hope that I'm wrong, and maybe I am wrong, but so that it does not give the appearance of such proclivity. I recall 25 years ago, and it's still the case, I'm sure, that parties, when they disagree, they agree eventually on an agreed medical examiner, which is not this medical examiner for one party or that medical examiner for the other party, but a third agreed medical examiner whose decision becomes binding on all parties. Now, are we going to go that far? Perhaps not. I have to backtrack and say that, you know, as much as I'd like people not to be out of pocket for somebody else's error, I would rather somebody else be more willing and inclined to agree that they've made an error, especially if that does not result in additional money coming out of the city for their admission of having made an error in the first place. Because ultimately that will then provide the applicant with the job that he or she wants. It will have come at an extra cost of some independent medical evaluation that he or she paid for.
It should
but
just come out of Matt's budget. That's it.
So I think
That resolves it.
I'm making my concerns known, and those are my concerns.
Honestly, if we're talking about reimbursement of a medical exam, I think the city, if they're going to make a decision that they've made a mistake, they should eat the cost. But I see your
Yes,
point,
they
you know. But at the end of the day,
That's what I think. I believe that if the Employee Health Services says, looking at the report, there's no way we're going to be able to rebut this report, and what our
It's only
doctor
fair.
says doesn't, so the health, at that point, they have to overturn their decision. If they don't,
Then what?
then the employee now has a very good chance of basically filing a civil lawsuit.
Oh, no, appealing to the commission.
Appealing to the commission, I apologize. That's what.
Let's encourage them to appeal to the commission.
If I could go through the process, and Commissioner Abkarian, it's correct. And this has been characterized as, you know, if the city's doctors made an error or a mistake, and they should be, you know, they should fix the mistake. And again, in most cases, this is a matter of of, the employee going through a medical exam, and for one reason or another, if they're found to be disqualified or not, fit to hold whatever position they're being tested for, they have the right to, essentially, it's a second opinion. And in the case of, what I think the hypothetical Mr. Chair used was a police psychological, we actually provide them with recommended doctors, or it has to be someone who is post-approved police psychologist, and there's just a handful of them, but has to be somebody who knows that. And as you can read in the rules, they have to read the job bulletin, they have to go through everything. So what happens is two things can happen. That second opinion, which is paid for by the candidate, they either concur with the initial opinion, which probably occurs 75 to 80% of the time, or they may say, no, we find this candidate perfectly suitable. And if that's the case, we would then have our employee health, our medical clinic review, the first doctor and the second doctor, so look at those together. And if they do concur that, that the second opinion is valid, then the employee would be allowed to proceed. If the medical staff affiliated with the city disagrees with that second opinion, then it would come before the commission, and the commission could then order yet a third opinion. That would be at the city's expense. So basically, city pays for the first one, applicant pays for the second one, the third one, if it gets that far, and it rarely does. This is pretty rare. The city would pay for that again, as determined by the commission.
If the health services decide we're going to overturn, then at that point, my recommendation is that we would actually have that employee reimbursed for that before they even get to this.
Employee or employee and/or applicant?
Employee
There's a
and or
distinction.
applicant.
Either one.
Either one, because again, I said, going for the police department, they have gone through every step of the way. They've gone through background checks. Their family has been interviewed. Their neighbors have been interviewed. They've gone through 4 months of a process, and now they could be police officers tomorrow, but for this one report.
I agree.
Well, employee and/or applicant, and Mr. Doyle remarking could be promotional.
It could be
That
promotional.
still means it's an employee who is an applicant for a higher position.
yes.
There is a distinction with what my colleague earlier was referencing as to an outside applicant, not yet an employee within the city.
Which is a police
Because an
officer.
employment right is a vested property right. And that person would not have that right. They have the right to apply to have that right, but they don't, that's not a vested right. No more than my privilege to drive a vehicle in the state of California. Once I acquire it, it's a property right. But my seeking acquisition is a bit different. So I would support an employee and/or an employee who is applying and therefore is an applicant for a promotion to be reimbursed, but I would caution against supporting every person who comes in from elsewhere trying to become an employee of the city of Glendale and then, because I don't know.
But the employee health services, once
the
they
one who calls
reverse it, they are the employees of the city. So it make, you guys pay, I don't see the distinction, I really don't.
They'd be
You
put
don't,
back.
you would have that job, but for the, I'm not saying mistake, but for the decision of the, that doctor. You would have that job, you have the job tomorrow.
It is a mistake.
It is
I
a
mean,
mistake.
It is
So
a mistake
human
on their
health
side, and they change their
services
position.
change their position, and now you don't get the job as a result.
I want to encourage them to change their
And
position.
recognizing the quality of your statements and the persuasiveness, but the reinstatement, assuming that the medical review officer within the city, upon his scrutiny or her scrutiny of the independent medical evaluation or the medical evaluation submitted by the applicant approves, all that does is reinstate the applicant to an eligible list against which the approving authority will make a decision as to which one of those 3 or 30 or 300 would be selected for the position. So I concur, as you have discussed.
Hold on, I don't know if that's really true, because in the police officer scenario that I brought up, police officer has the job, doesn't go into the eligibility list.
I'm suggesting across the board.
For promotion, you would go, wouldn't you?
If I
No,
can
he's
clarify.
passed through everything.
We wouldn't send an employee through a medical unless they were offered a job.
Remember that this is not employee. I am discussing candidates, not employees. That is the very significant
No. This is
distinction.
a candidate does not get the job. You offer the job and they have to pass the medical or
That's
pass
the only
whatever.
thing that's stopping them from becoming an employee.
It's a conditional
So
offer.
it's a conditional offer. They give you an offer, you're an employee, but you have to pass the medical
And it would
portion.
be illegal for us to
Ask for-
give a conditional offer and then have them take a medical and then decide at the last minute, oh, we change our mind. That would open us up.
They
for
do have a vested interest because they've already been offered the job.
Okay.
Mr.
Well, I've been taking all this in.
Yes.
Everybody has great points, I have to concur. But my question is to Matt, how many people are we talking about that would fall under this? How many do we?
A year.
Huh?
Don't tell me one.
If I agree to
Are we
pay for
talking
it, can
about
we
3
move
people
on?
or
Mr.
10?
Chair, Commissioner Devine, that's a great question. This is pretty rare. I would have to say, I mean, confirm this with me, maybe one a year that this comes up. So I don't want to take one side or the other in this debate, but if the concern relates to the impact on my budget or the city's budget, it wouldn't be significant. But this does not come up very often.
And with that, I would say, while I certainly agree with Commissioner McCarley and Commissioner Gazarian and their points, I think I'm going to use the words of our famous chair. It says, called "Do the Right Thing." And to me, doing the right thing would apply to anybody that's subjected to a erroneous decision by the staff. They should be entitled to, whether they're a candidate or an employee, the right thing to do would be to reimburse them. And again, looking at the fiscal impact on the city, it's like 10 cents.
Told you you're paying for it.
So I think we've spent, close to an hour now talking about this. I would support Mr. Abkarian's original proposal to allow reimbursement.
Me too.
I would agree in light of the entirety of the discussion, but I would ask that it be made very specific that where it refers to the eligible, whether it's an employee or an applicant, obtaining at his or her own expense an independent medical examination report, when we are redlining page 32, subsection E on top, and be reimbursed reasonable medical expenses, we are talking about reasonable medical expenses for acquiring the independent medical examination report, and not reasonable medical expenses, meaning I'm now distraught and I need therapy for a year.
That's a very good point.
That's an attorney talking. There
That's
you
a
go.
very good point.
And
That's very good.
I
That's
also, I would
exact-
put in another word there. This comes off the explanation of benefits we get from our health plans. It's called reasonable and customary. So that there can be some, let's say one of these doctors charges a fee that's not customary for that type of work. So that would narrow it down. But again, with one a year, we're really not really talking about a lot of money here. So I would just say reimbursed reasonable and customary medical expenses.
As noted in section 8B.
I mean, what we're asking is reimbursement for the cost of the exam. It's not like they're getting medical care.
No,
Correct.
It's
So-
the exam.
Yeah, but if they go and they get a doctor, then they pay him $10,000, and the actual cost of an exam is $1,000, you're not gonna pay him $10,000, you're gonna give him $1,000.
No, we wouldn't.
That's basically what it is. Why we put
I can-
reasonable and customary medical.
I can give the exact language.
Go ahead.
The exact language ought to be something along the lines of, and be reimbursed reasonable medical expense of the independent medical examination.
As noted in 8B.
Right, something like that.
And customary.
Customary.
So the question then, from a process perspective, do you want to take a separate vote on this? Because there's quite a bit of discussion.
I wanna take a separate vote on this one.
So would you like to do that now? That might
Yes.
be a good idea.
There was a first and a second. Could we have roll call on this item, please, based on the language that Mr. Kazarian
Chair.
just read.
Mr. Chair, if I may read that language just to make sure I have it right. So the line would say, after reviewing the report, withdraws the disqualification. The eligible shall be restored to the eligible list and be reimbursed reasonable and customary medical expenses associated with the
Acquisition.
Independent medical examination report
examination associated
required in
In
Section 8B.
Section 8.
the medical examination.
As required in Section 8B.
Okay.
It's not really required.
Oh, no,
It's
no,
it's
just
it's
as-
elective, as set
Or
forth.
reference.
As set forth in Section 8B.
Okay, as set forth, okay.
Let the guy do the roll call,
So
please.
you
Go
have
ahead.
a motion and a second.
Get it right.
Motion and second, roll call, please.
Commissioner Minikin,
Yes.
Commissioner Kazarian,
Yes.
Commissioner McCarley,
No.
Commissioner Devine,
Yes.
Chair Abkarian.
Yes. Okay, the next one is Section 10. All I recommended in here, and I had a discussion with Matt on this, is that only the permission of the Director of Human Resources and Commission as uniformly applied to every applicant. So it says that a applicant, whether accepted or rejected, shall remain on the file and shall not be returned. Defect or omissions in the application on the file may be corrected and supplied only with the permission of the human Resources as uniformly applied to every applicant. That means they can't say, Joe could go ahead and make the changes, but Jim cannot. So it just has to be, if they're gonna make allow someone to change a defect or an omission, it has to be uniformly applied to all applicants.
I agree.
I guess I did not understand the language, your additional words, because when you follow the word commission with as uniformly applied to every applicant.
Oh, no. I said it has to be uniformly applied to.
Right, that
Grammatically,
sentence, yeah,
grammatically, just let's make sure. I was going through this,
Okay.
and I basically made notes.
Okay.
These aren't actual sentences that I'm making
Because I
recommendations.
put a question mark. I'm
Yeah,
thinking,
no,
what does the sentence
No,
mean?
let's make sure that
Okay.
I'm going through this, each paragraph, and I'm making notes. None of these are grammatically correct in any way, shape, or form, and I don't.
It's the theory.
Okay,
It's
all
a
right.
recommendation.
Okay.
Suggestion, so now we can grammatically put it any way you want to. Defect resources, uniform,
And must be uniformly applied.
and must be uniformly
That's
applied.
it, as to all applicants,
And must be uniformly applied.
as
To
to
all
all
applicants.
to all applicants, yeah.
Motion to that effect.
Any objection to this?
You don't
Okay,
need a separate
that's
motion.
approved. Move to the next one. I go through them fast. Page 34. Okay,
Is
that
this
one's
one-
done. That
we've
one's
done
done.
that, yes, exactly.
Page 35. Oh, we wanted to include community panel in this discussion in the oral board examinations, and there were nowhere that there was a specific mention of a community panel. So when I talked to Matt, he recommended that we put, which may include professional, internal, or a community panel. So we include a community panel in here just in case if we want to include one in the future.
I have no problem with it, with any of that. I do want to return to my proclivity to interpret words that I often come into contact with in statutes. And may is permissive and shall is mandatory. So when you say may, it does not mean that it shall include a professional, internal, or community panels. I just want you to know that's what you are saying. You're saying may. That if it's may, then somebody is going to make that decision versus it is in black and white, or in red, in this case, that it shall include. I recall in the past, we have, have had very heartfelt discussions about community panels, the value, the pitfalls, and all the other stuff. And I have held different beliefs as to those based on different feedbacks I've received, and then subsequent feedback I've received that led me to believe that the earlier feedback was really not taken as it was supposed to have been given to me. So if we are now going to add language, I would be a proponent of adding language that says which shall include, as opposed to may include. So
The
I just
reason
want
we
to be,
say-
I just want to be, I've always been straight up and upfront with all
I
of you folks.
appreciate that.
Okay?
This is, I think, in my opinion, my understanding of this is on a case-by-case, but if you wanted to add a panel in a
Which is what I
specific posting,
understand.
it would, be you have the right to do so, that's all.
Yeah, I think
That's my
that there are
understanding.
some panels that doesn't require community panels. There are some that
most
do,
of them, yeah.
most. There's some that we would want to have community panels, and in fact, it is mandatory. So
Well, there are
if
some
we
that
say
we took-
shall, it said we shall include, that means that every single panel needs to be professional, internal, and a community panel. And this basically says we decide which one we want to put in on each one of these.
Where does it say we decide? Grading of examinations, and how many panels require oral board examinations? My understanding.
How about if we say as decide, which may include professional, internal, or community panel as decided,
As determined by
as determined by
the
the
commission?
Civil Service Commission.
No.
No?
No, no.
Mr. Chair, we do examinations every day of our lives, and we have no capacity to bring everything to the commission to determine which type of exam to do, let alone whether on an oral board we're going to do a professional, internal, or community panel. It's a determination made by staff when we do our processes. So I think the language that the chair provided is fine as is. It allows for the option of having various types of examinations, even within the heading of oral board examinations. So I'd prefer it to be.
But this is what I need to have a better understanding of, because I am not going to, walk out of here and have somebody tomorrow tell me you made the wrong decision, because this has been happening over the years, and I take it to heart, because I do not sit here to make wrong decisions. I do not have favorites in this equation whatsoever. So if you are going to tell me we do a lot of examinations, Mr. Doyle, I can respect that. Please tell me, if you may, oral board examinations. My understanding of oral board examinations, and I confess it's not a complete understanding, thus far is the following. Oral board examinations are given to those who are rising in rank in management supervisory roles, and I can only think of the police department. Now, I suppose, I suspect I'm wrong. Is this across the city departments every day, as you say, we do promotions and there's oral board examinations? Because if that's the case, you're absolutely right. You can't be running to us, and that would create chaos. So if you
Mr.
could
Chair,
enlighten me.
Commissioner Gazarian, yes, I would say probably 98% of the recruitment processes that we conduct involve an interview panel, an oral board examination generally at the tail end of that.
Okay.
Sometimes there's a written exam first. There might be a practical exam first, but for the most part, most of the time, we end up with an oral board examination, and we contact other agencies and get subject matter experts to sit on that panel and evaluate candidates as they come through. Most of our processes culminate with that process. Very few, some of our field operations where we want to see how you can drive a truck or be a fire engineer or something like that, where we'll do strictly practical. But this is done almost with every process.
So, Mr. Chair,
Yes.
perhaps wrapping this up, the language that you have suggested is acceptable to me. The language, Mr. Gazarian, that you are suggesting, very, very interesting. I think it would be a dramatic
Yes.
push forward
I
in
agree.
human relations,
I agree.
HR processes in this city and other cities. I would have reservations about incorporating the verb shall
Yeah.
at this particular
No,
point.
I agree.
And would support only Chairman Abkarian's inclusive language, which continues to provide discretion to our HR chair to select the panels.
My recommendation, the reason that I brought this up was because nowhere in this rules was there ever a mention of a community panel. And I wanted to include that somewhere in this rules, that there is a community panel, and that could be a process, and that's something that we have a right to consider.
And if in the bulletin we decide to bring that back, at least it's covered here.
Okay.
That's my understanding of it. I support that.
I'm satisfied in light of the explanation provided by Mr. Doyle.
Any objection to including that in? No objection, that's included. The next one, it just says appearance of bias or an appearance of bias, instead of just the actual bias.
Appropriate grammatical
Is there any,
change.
yeah,
Yes.
okay.
I agree.
That's included. Okay, the number B, I think, is a very, very long discussion. I would like to bring that back at some point in the future to discuss the weight of how we weigh each section, written being 10% and then the oral being 80% or whatever it is. I would like to take a look at those weights, just to make sure that we're all comfortable. So we can just skip that. I will bring this up at some future point.
Is it going to come back in its current format? This is still in the rules? This is the language?
The
right now?
language is in the rules. I just want to look at the weight
Until
that
we
we
get
actually put
together
on
and
each
go over it.
exam
Okay.
and how we come up with those weights.
I agree.
Okay.
Which, so the language will stay,
I will
Mainly
reserve
the same.
comments until you bring it
yeah,
back.
I think that's what.
Okay.
The next one, I think, is 38.5. No, we already talked about that. Next one is 41. This one was where the Director of Human Resources approves a temporary appointment. I would like to put a limit of 6 months, that a temporary appointment can never be more than 6 months. If it's more than 6 months, it has to come in front of Civil Service Commission. We have to approve any temporary appointment more than 6 months.
May I suggest, Mr. Chair, that your language, looking at it within Article 24, is consistent with temporary seasonal appointments as referenced in Section 2, subparens 8. So your additional language is consistent with the charter.
Correct. Charter says temporary employment is 6 months. Director of Human Resources could put someone to temporary appointment for 6 months as far as they believe that they're qualified, and anything after 6 months, it has to be approved by the Civil Service Commission. I don't even think anyone could be appointed based on a charter more than 6 months as a temporary employee.
Don't they hit that
Chair-
limitation on the hourly as well?
The only circumstance I can think of, and maybe I'm, not thinking of everything, but our MOUs do allow for acting appointments, people who are, filling in for a vacancy. And, if you have a situation where someone is out on some type of extended leave or just, the department would like to make an interim appointment for some period of time, that might, end up being very long. And I don't know, Mr. Chair, if that is what you were focusing on, interim and acting appointments?
If I may.
I would basically say that what I was looking at, there's a section that Mr. McCarley just pointed, Section 8 in the charter. But what I was really looking at, saying even in that case, if that appointment is more than 6 months, it has to come in front of us. An explanation is given to us. 5 people will review it just for transparency. Then we would vote on it, and then you can extend it. But until you come in from a Civil Service Commission for a temporary appointment, if it's no more than 6 months, it has to come in front of us for us to approve a temporary appointment past 6 months.
Or we either we're characterizing it as temporary appointment beyond 6 months, or for purposes of a reappointment.
Sure.
We would approve the
We would, that the commission be made aware.
Any temporary appointment longer than 6 months should be,
regular employment.
you guys are the attorneys for love of
The only
God.
thing I'm suggesting is to maintain consistency between the charter, which trumps these rules,
Yeah.
and the charter is fully explanatory, it's operational. I think we've had deviations from that policy over time, and we as a commission are correcting it, and we applaud Chair Abkarian for bringing that up for our review.
Any objections to extending, have review of temporary appointment for past 6 months by the Civil Service Commission? no objection, that would
Mr.
be
Chair,
included.
Again,
Yes.
I'm not objecting. I'm not sure the
Make a
implications this would have on acting appointments and interim appointments.
Anything more than 6 months has to still come in front of us, and we
So
have to
your intent would be to apply that to,
to every employee in the city of Glendale that has a temporary appointment past 6 months, that is current or in the past, that has passed the 6 months, has to come in front of the Civil Service Commission, and we have to appoint all those appointments.
We have to appoint or?
Or we have to,
just
I'm sorry,
review?
review the temporary appointment past
Oh,
6
the
months.
reappointment, yeah.
Based on the charter, sections 8, and based on our own rules that we're going to add now.
Do we currently, dare I ask, if we currently have individuals in our city who are in an interim setting beyond 6 months already? Is
don't-
that an issue?
I don't know, but I
see.
do know
Okay.
for various
If-
reasons, they,
Yeah.
they may go on for several
Well,
months.
think about this, and if there's going to be an issue, I mean, these are recommendations, we're going to vote on
That's
this
right, we
later on anyways.
If they're continuously been employed with the city of Glendale for 6 months or total of 6 months, they need to come in and they need to get it approved based on the charter language and based on what we just approved.
And I would suggest also, Mr. Doyle, that at some point, our recommendations would in fact be vetted with the associations and as well must be approved by the council. On that particular point in time, this might be contentious. You'll have an opportunity to address. The new city manager will bring focus on that, and the city attorney might come forth with any issues with respect to this and any history regarding temporary appointments. The council could say, no, we're going to change the charter, which is in the province of the
Then
city
you can
council.
blame Albert.
Then we can blame Albert for causing all this hell.
These
Throw
are,
him under the bus.
First we applaud him, now we blame
That's
him.
exactly right.
Chair Perian, just a quick comment that you made a moment ago. You said, I understood your comments until now to mean that it was consecutive 6 months. And I think you just made the comment that it could be a total
no,
of 6
no,
months.
I'm sorry, consecutive 6 months.
Got it, okay.
I think that that's very clear in the city charter. It's very clear here. I don't see how we could deviate from it, except that it has to come through somebody. The city, the citizens of this city want transparency. And if we're gonna hire someone for more than 6 months in this city, then it has to come in front of us, so we at least have, I don't wanna be called a rubber stamp at least, and we can at least review
Yeah.
it and say, yes, that's appropriate and we should do it.
47.
Mr. Chair,
Okay, no problem.
if the commission wishes to proceed with this, could I recommend that this be contained in section 9B as opposed to section 2G? I just think it makes more sense there. Or just somewhere in section 9, in the same,
Temporary employment. Temporary appointment under section 9B, and just move that language. You're just suggesting an edit, a cut and paste.
the requirement that you're proposing that these be brought before the commission. Or we could put it in both sections, I guess.
I would leave it on both sections just for clarity. I would just leave it in both sections.
It's the
You
same-
can repeat it again if you like in this section. This way, then for clarity, then we don't take out the structure of what we have already in the rules.
Okay. So that would be, again, section 2G and section 9B, same issue, pretty much.
Right.
Are the commission
And then,
approving
and
this
then
by
that human
acclamation?
resources will be, unless extension is granted by commission for a leave of absence or an emergency. Oh, no, I'm sorry, Director of Human Resources or commission, or I want to say temporary appointment may fill permanent classified position for up to 6 months unless extension is granted by the commission, yes.
Correct.
Yeah, my reading is that the Director of Human Resources would be stricken, and it would be
Correct,
solely
commission.
the purview of the commission.
That is correct.
Okay.
All
how much further we can get until 7 o'clock in this, and then we'll, I think there's nothing until 47.
Page 42, did you?
Some of
No, those are
already reviewed.
On page 47,
Page 43.
uh,
45.
reporting period. In here, it says it has to be, no later than 10 calendar days after the close of each employee's
Sorry, what
respective
page are
reporting
you on,
period.
sir?
I'm sorry, page 47. I don't think there's anything.
Section 2.
Okay, so page 45, that was already dealt with.
That was already dealt with.
Last month.
Page 47, it says that all job performance evaluation reports shall be prepared with reporting period, and it says 10 days from the close. God knows that this is definitely, someone made a mistake on this many, many years ago. So
Yeah,
it has to be, I would say it has to say, not 10 days, it has to say as set forth by the commission from time to time. Rules as set forth by commission from time to time. This way, then if we change it to 10 days, it could be 10. If you said 90 days, it would be 90 days.
that's perfect.
Any objections to
No.
that?
Agreed.
Okay,
Next.
that's approved. Page 49, I said this should be HR's responsibility unless there is an appeal. The committee examination of health establishment is released for any position. The commission shall determine whether such examination shall be open, promotional, or both. I thought it was an HR decision to decide if it's an open, promotion, or both.
My recommendation, well, maybe we should listen to
Sure.
the HR
Go.
director.
Mr. Chair, members of the commission, this does seem kind of redundant relative to what's already in the rules in Rule 4, Section 3, which addresses when we do an open process versus a promotional. So
Should we
frankly-
just delete
frankly,
that
I'm not-
section altogether?
I'm not even sure what purpose it serves.
Okay, so let's vote on deleting that entire section,
Bless
if
you.
everyone is okay and there's no opposition. Delete the
Just
entire section.
Not to belabor this, because
Sure.
we do have a time factor involved, but I don't want to give up the authority of the commission, the inherent authority in the commission to determine whether an examination should be open, promotional, or both. Even this evening, and our distinguished chief addressed us regarding a new position in the department, and he identified that position as promotional. And of course, out of deference and respect for his understanding of his department, we acceded to that. But it might have made a very interesting conversation amongst us if we were to suggest that that be an open promotional opportunity, or open opportunity, rather than a mere promotional opportunity, allowing other individuals, not otherwise yet members of our community of city employees, to apply for that position. It
So-
might, and that's why I tend to defer to promotion activities, employment activities that are expansive as possible, meaning open.
Go ahead.
Mr. Chair, members of the commission, excellent point raised by Commissioner McCarley. However, the rules, the charter as they're constructed, contain great protections for employees and their rights.
That's
And
perfect.
the whole purpose of most of what's contained in Roman numeral 4 is to protect those rights, which is why when, for example, we take a recruitment process that was formerly done promotional, and the department may want to go open with that, which is one of the few occasions where we have to bring a bulletin before the commission, and that's to protect the rights of our employees. If they believe, hey, there are a sufficient number of candidates internally, why not keep it on a promotional basis? So the rules as a whole sort of skew toward the promotional, and if we were to begin directing departments to go open or to go that direction, it would be great harm to our employee groups and our employees in general. So
I might,
that's my only
I
comment.
might suggest that I am not differing with Mr. Doyle. I am just indicating that the decision, ultimate decision, as to whether or not that solicitation for employees is one that should be reserved, at the end of the day, should be reserved to us, because that is significant. Of course, taking into consideration, the deepest consideration, the protection of our employees and affording those employees the opportunity to move forward in their careers up a promotional ladder that ultimately terminates at some point, such as retirement. But we should be the ones to determine at the beginning whether that's open or promotional. It's as simple as a summary proceeding. It's comparable to what we're doing right now. Otherwise, we're giving up our authorities.
Chair Karian?
Yes.
It goes to a comment you made earlier, Chair Afgharian, that you don't want to be a rubber stamp. Neither do I, and nor do I believe anybody on this body wants to be a rubber stamp. And it is my recollection that each and every time Chief Examiner Doyle brings a particular bulletin here, there's healthy dialogue. And I recall my colleague, Commissioner Devine, oftentimes, for lack of a better word, perhaps scrutinizing or asking pointed questions about why it is not open or promotional, or why is it this and not the other. I've always been led to believe, based on that discourse, that ultimate authority to weigh in does lie with this body. If I'm mistaken, and in fact, the exercises that I've taken part in the past have been just for information purpose for us as to what it is that's out there and what you guys are doing. It's we're doing a promotional, we're doing an open, or we're doing a combination, and we're supposed to just sit here and go, okay. Then I don't understand why we've done that all along.
Okay, you know what, let's keep section 2 and not make changes, because it does say commissioners shall determine whether such an examination shall be open, promotional, or both.
That's right.
Okay.
So let's just keep that.
Thank you.
Even if it's repetitive.
Okay.
That's fine.
Thank you,
And
Is everyone okay
Chair.
with that?
reading that, that last sentence is kind of an important one as well, where it says, if an examination, both promotional and open, is held, the eligible list resulting from the open examination shall not be used when there are 3 persons eligible on the appropriate promotional list who are willing to accept the appointment. What that says is, when it's a promotional open process, we take the promotionals first.
And then go to the open.
That's fine.
And that, I think that's an
Okay,
important.
That's
let's just
fine.
leave, this is
reaffirm,
okay,
so-
we're gonna leave it as is, no objection, we're gonna leave it. Next one, I'm just going to go ahead and withdraw that, unless if somebody has any comments on this particular item.
Yeah, I did not understand what you meant. Very
Okay,
seldom used.
That's why I'm withdrawing it, Mr. Page 50.
I had 3 question marks.
Once you put 4, then I'll address it. Commissioner, Employee Association, okay with it? I'm not an issue with that.
Are you at
53
page
was
53?
Yes.
Yeah, but that was extensively discussed last time. I know I registered a no vote. It's been-
Extending leaves of absence.
Yeah,
Did we discuss that? Did we already decide that? Did we decide this?
I extended leave of absence.
I want to say by who?
This was staff's recommendation number
Staff
5.
recommendation.
Okay, so we have already
Yeah,
addressed
this
it.
is,
was a
this
vote.
I don't want to
is,
read.
this is that, and we were for all commissioners.
Okay, yeah.
Okay, going to, I
We're gonna
apologize,
get
I'm gonna go
through.
through them fast. On appeal,
Salary step.
I want to include a M-step reduction as being, I'm sorry, page 56.
Okay.
I want to include a salary step reduction. If somebody's salary M-step is not given to them because a manager believes they shouldn't get a M-step or a salary increase.
What's an M step?
M-step is a additional bonus that is given to you. And in the past, they said that the M-step, if somebody doesn't get their M-step, for whatever reason, the manager decided they're not gonna give it to you, then that is not appealable to the Civil Service Commission. A number of times, the city manager's office has said that to a number of employees, and they have communicated that to me. I believe that that's a right that they have, that's being taken away from them, no different than a salary. Accordingly, I want to include reduction in classification or a salary step reduction, just so we have a right, the employee has a right, if their M-step or salary steps reduction is taken away from them by a manager, that they have a right to come to Civil Service Commission to appeal that decision.
It seems to me, Chair Abkarian, that the only possible reason one would not get that bonus would be because the supervisor doesn't deem the person is deserving of it, which in a form or a way is a disciplinary sanction of sorts by reduction of pay.
And if that happens, and if it's unfair, then the employee should have a right to bring that in front of a Civil Service Commission, and Civil Service Commission will decide, is it fair or unfair?
Mr. Chair, if I may provide some context to this, and when you suggested this, Mr. Chair, I didn't anticipate the circumstance that you're bringing up involving merit step. Merit step, by the way, is a contractual agreement. It used to be with all of our non-management bargaining units. However, in recent negotiations, probably the last 10 to 12 years, those have been negotiated away for all the groups except for the GPOA. So GCA, for example, has, I believe it's nine steps, and all the steps are equally valued. The Glendale Management Association has 8 steps, and they're all the same, 1, 2, 3, 4, 1 through 8.
Who decides
the
who
GPOA?
should get the M step?
The GPOA has, I believe it's 5 steps, and then the 6th step is what's called a merit step, or the M step. And under the collective bargaining agreement between the city and the GPOA, it indicates that an employee shall not be advanced to that merit step until they attain an evaluation that successfully meets or exemplary.
But if the manager decides, I'm not gonna give you that, no matter what you tell me, no matter how good of a job you do, I'm never gonna give you an excellent on your, because I just don't like you. I'm never gonna give you an excellent on your evaluation for the next 10 years. And now the employee is able to get the M step, but the manager is not gonna give them that excellent evaluation. Then that employee should have a right to come in front of us and say, listen, this is what I've done. This is all the employees. This is all the other managers. This is everything that's happened. This manager just doesn't like me. That's the only reason I'm not getting the M step. And they should have a right to at least appeal in front of us. I'm not saying they're gonna get it. I'm just saying they should have a right to at least appeal it to the Civil Service Commission.
But I recall within the last hour, I believe it was you, Chair Abkarian, who made a remark that we should not be getting involved in the performance evaluations and grading of whether somebody meets standards or exceeds standards. I may have misheard. I could have sworn that there was.
Today?
Yeah, I thought so. And maybe I'm wrong. But let me. If I'm wrong, let me ask this: do we ever sit in judgment of whether an employee deserves a satisfactory, above satisfactory, or exemplary? I don't think we do.
No.
Right? So
I agree with that. However, those evaluations do not take away something from the employee.
No. Well, following up in your what if scenario, if the what if is that the only way they would get, as Mr. Doyle suggested, that they would not get that 6th step unless they exceeded the standard, their evaluation standard was a meets or exceeds standards. Yes, you're right. Maybe they may not get it for some personal, hiccup between the two individuals. But how are we going to then sit in judgment of whether that person is getting or not getting the exceed standards that deserves or kicks in the M bonus or doesn't kick in the M bonus? It seems to me that if that person has an issue, if that aggrieved employee has an issue, that aggrieved employee for a work environment complaint-based grievance will go through the city manager. And if it doesn't get anywhere beyond that, does that employee then have any kind of a beyond that?
No.
No.
Not on the M step, they don't have a right to come to the Civil Service Commission.
Mr. Chair, if I could, I believe, resolve this right
Sure.
now. I think it's, I think having thought about it and discussing this with Ms. Hunanian, I think Mr. Chair's proposal is appropriate. The only group, as I've said earlier, that continues to have the merit step is GPOA. All of the other groups through collective bargaining have just dealt with it, have negotiated it away, and it's actually to the employee's favor because there's not that higher standard in order to get that final step. So I believe what we're talking about is the removal of that step, not the advancement to it. Our understanding would be under the Peace Officer Bill of Rights, even if an employee, if an officer has attained the merit step, even if that were removed due to poor job performance, that would still constitute a taking away of a property interest right, and with which they would be able to appeal not only through the Skelly process but through the commission. So I think the proposal is appropriate.
But if I may ask, is it worded properly in here?
Yeah, I don't know what the wording is.
For any salary step reduction, and this is, believe it or not, a increasingly common form of discipline that is administered, particularly, I'll talk about our fire department, where, if someone does, commits some act of misconduct requiring discipline, and, in the old days, we would give them a, 3-shift suspension or something like that. The harm that does, that firefighter being out for 3 shifts, meaning we have to fill that position with someone on overtime, the cost of that is pretty significant. So we're moving more toward a discipline that involves taking away money in the form of salary steps. And those are certainly, I use the example of the Firefighters Association. They don't have a merit step, but we may say, a firefighter so-and-so is going to be reduced from salary step 6 to salary step 5 for the period of 6 months, and that's the discipline. And
That's appealable, though, right?
Excuse me?
That's appealable.
And that is absolutely appealable.
Okay.
So these step reductions
Should be appealable as
are
well.
appealable, yes.
Yeah,
And again,
okay.
thinking about it, only GPOA with the merit step, they would have the appeal rights anyhow.
All
So
right. We can get through
we
this.
can
So
accept
we'll
that.
just include it unless if there's an objection. No objection. I think the last one, we're down to the last
We
one.
got subpoena?
Yeah. We've had in the, I just included this in here as the certificate of imposition of contempt sanction for any following behavior. We've had one occasion where we had an actual hearing and an employee was subpoenaed, and that employee basically said, well, I'm not gonna go, what are they gonna do? I'm not gonna go to a Civil Service Commission hearing, what are they gonna do? So I want to make sure that there's a mention of including a subpoena by the commission as a contempt sanction. This way, then there are no questions by an employee that if they don't show up, what will happen?
Mr. Chair, I have no reservation about supporting that. I would refer the commission to the Charter 24, Section 3, which does empower you and this body to issue subpoenas. I believe those subpoenas for enforceability would have to go across the street, and then once confirmed, it's a ministerial process across the street, the Superior Court once confirmed, then of course you can make an apprehension of the witness who fails to appear. But I would be in
I just want
complete
to make it very
support
clear.
of your position.
It seems to me that you want to make it clear, and I have no issue with that, Sheriff Karian.
That's why it's being
For the likes of you and I and others perhaps, it is clear because it talks
It
about
says to lawful order.
lawful
of the
order.
commission. I
Right,
understand,
that's
I
why.
understand.
So if this commission says we are ordering this particular party to appear before us, as we have from time to time a department head on a Fort notice, and the person runs in here, well, if they didn't run in here, they would be in violation of that lawful order, and we would have the discretion, I suppose.
If you think that that's clear, then we don't have to add it
Good.
as including subpoena at all. If if you think that that's clear.
I do, but
do.
that's me, yeah.
I do.
All right, why don't we just go ahead and take that
What
out?
about Commissioner
Is
Devine?
that okay with you, then, Commissioner Devine?
Okay.
All right, so
That's approved.
that's approved. Okay, we're done with this, let's finish. Let's done with this.
But,
So now, this package with the changes approved by the Civil Service Commission will go in front of the employee associate, with the discussion with the employee association for discussion with them.
And you'll bring one or two items that were left back
Yes,
sometime.
back from that.
Chair Perrin, I think it would be appropriate at this time to take a collective motion on all of the items that were discussed.
Yeah, but one of the items we
Yes, I've
disapproved.
pulled them, and I could tell you, just for the record-keeping purposes,
ahead,
what
please.
pages they're on. So there was one change on page 21, two on page 29, one on 32, two on 35, one on 41, one on 43, one on 47, and one on page 56. That does not include the one item on page 32 that was already decided.
Okay, so with that, could we get a roll call on approval of
Mr.
all of
Chair?
those? Yes.
You need a motion.
I'm
Hold on.
sorry, you're going to hate me for this, but I think we skipped something.
I think it was
What page
previously
is that?
decided.
Page 42. I think we were looking at, when we were discussing that issue with temporary appointments, on page 41 and 43.
The repeal of certification,
Yeah, the
is that what
repeal
you're?
of certification, sir, if you want to cover that.
This basically says that if a human director may repeal a certificate from appointing authority who has held a certificate for at least 10 working days without making an appointment. And the reason I say this should come in front of the commission is because how about if the manager gets a list of 3 and doesn't like any of those 3 people, and basically holds the appointing authority holds a certificate for 10 days without doing anything, then the human resources has to, without making an appointment, extension of time may be granted by Director of Human Resources, but decides, I'm not gonna do this. Then what? I'm not gonna certify the list.
Is this a scenario where you have 3 people who are now deemed qualified for some promotion, but the department head doesn't promote any of them for 10 days?
No, they don't certify the list for them to be, is that what my understanding was that?
No, Mr. Chair, these are names that are certified to the list, and for one reason or another, the
Department head.
department's choosing to not utilize the list. And this does happen. There are a variety of reasons that they may not want to proceed. Sometimes it's budgetary issues, something comes up, or a reorganization may be necessary, or they may get direction from the city manager to go another direction, or...
All I say is, once that list is certified, if they're not going to go ahead and make any appointment, that list, information should come in front of us for us to basically see. If we want additional information, then we can ask the department head to.
Repealing it means, that means
Essentially canceling.
canceling.
It's not canceling the exam, it's canceling the certification, and
Canceling the successful certification of people who passed the exam, right?
Yes.
That's not right.
Yeah, well, that's what
That doesn't sound right.
So what happens in a case where you certify 3 names to a department head? The department head really wanted the 4th one on the list. He couldn't reach it, so he doesn't hit
anything
one
for
in
10
10 days. And then you say that certification is canceled. Does that allow the department head now to ask for a new
Retest.
certification and get down to the person he really wants? Which may
No, you have to retest again.
no,
But then the 3 people got penalized.
But within the internal fabric of the city administration, is that failure on the part of a senior department head to select from the certified list reportable to the city manager?
as it stands now, no.
Because in essence, what that does is it indicates that a staff director has refused to move forward with an appointment. Now, whether the basis for that is budget or dislike of those identified on the certified list, but it appears to be in consonant with perhaps the direction of the city manager to adequately staff her city government.
It could be. Again, there are a lot of reasons that this may occur, but the scenario Commissioner Devine presents, that department head or appointing authority would be stuck. Essentially, they would not be able to reach number 4. They would have to wait if they don't want to utilize that list. And
What happens then?
They have to retest.
it sits still.
Until the list expires? So it could sit for 2 years without him or her being able to...
There may be good reasons. There
Well,
may be
the appointing
valid reasons, including, if, the appointing authority may have done reference checks on these individuals and found that 2 of the 3 are, were fired from their last job for theft or something like that.
Wouldn't they do that before they're appointed to the list? That's what I thought they would do, some background checks before they were. No?
Might I suggest that
Ms. Kazarian had a hand, so then I'll could get to it.
This is very disturbing, Mr. Doyle. It's disturbing because any number of scenarios can develop, some of which may be perfectly within reason that the appointing authority is acting, and others may be entirely improper. My recommendation to my colleagues is the following, Sheriff Carrion, that rather than the Director of Human Resources repealing or having the option to repeal after 10 days or having the option to grant an extension of time, if there is such an impasse, that the appointing authority who has been vested with that certification appear before this commission and give his or her reasons as to why that's not acceptable.
So you can just put Civil Service Commission may repeal a certificate from appointment authority who have held the certification within 10 days and make an appointment extension. Civil Service Commission may request their certificate to be appointment authority who has had a certificate maybe.
Mr. Chair, I am much more comfortable with the original language that you incorporated, that is a report, because that would be of value, and it's sort of consistent with my concern about the overall management of a city, that indicates that something is going on within that department. Now, whether that is malicious in a sense that the department head cannot accept candidates that have been certified, or it's a departmental issue regarding budget or change in operational processes, that should filter its way up to you and this commission. And so therefore I support your language as originally illuminated on that document.
And we could prepare a report monthly as needed. I honestly, I don't think this happens that often, but that wouldn't be, that wouldn't be as cumbersome as having a department.
There's 2 scenarios. Let me just make sure that we understand, Mr. Doyle.
Would prefer not to
One
do that.
scenario is that a list has been approved and the appointing authority decide, I'm not going to appoint anyone, I'm going to wait 2 years until the list expires, I'm going to do a brand new list. That's one scenario. Then you have this, correct? That's one scenario.
That's correct.
The second is that a appointing authority for 10 days does nothing with the list.
Well,
Correct.
Isn't that the same?
No, one is a little bit different. They could do something with the list and say, okay, I'll take the list for legal reasons. And then sit on it for 2 years and do nothing, and then when the list expires, they do a new testing. This one, you don't even, do you hold the certificate for more than 10 days, correct?
I don't think the 10 days is all that relevant. It really is, is the appointing authority going to make an appointment or not? And if they choose not, then unfortunately they suffer the consequences of having to not be able to fill that position.
But if they don't like the top 3 candidates, then
Okay, they don't sit with the consequences. The people who are on the list suffer the consequences, Mr. Doyle, and I am really, really upset at the context and the notion that a certification may be repealed just because an appointing authority sits on it for 10 days and heaven forbid you or this body repeals that certification. That's basically making a mockery of the entire process. It really is making a mockery. That appointing authority is not in private practice or a business, unlike me or others. that appointing authority has the city to answer to, has the council to answer to, city management to answer to, and dare I say this commission and the employees, to then certify someone for a potential position or a promotion, and have an appointing authority do nothing for 10 days, forcing essentially the hand of Director of Human Resources to do one or two things. Either repeal it or grant an extension of time without the appointing authority ever being held accountable to come and even give a reason that may be very rational reason, essentially makes me personally feel like I'm an idiot sitting here. And I frankly don't want to be feeling that way. If there's going to be repealing of these kind of things, unless the charter prohibits the commission from looking at it, I would like the commission to be able to look at it as to what's going on.
And after we look at it, what options do we have?
We have investigative rights to
Well, can we order the department head and say, we don't agree with your reasoning, so you must hire one of those three? In other words, what is the purpose
good
of
question.
looking at it and asking for his
No,
reasons?
let me just make
Let's say
sure.
we don't agree with
Hold
his
on, let
reasons.
me just make sure that we understand. The powers that the Civil Service Commission would have at that point is an investigative power, where then you can make him hire one of the three, but you can investigate and go into your investigative power at that point and do what you need to do at that point.
I do believe that with regard to the specific inquiry regarding investigation, that is something that the commission requested that our office review, so we haven't come back to you with a report
Correct.
regarding that. So, yeah, there's no response to that. I think what you're saying is that you'd want at least a reporting requirement so that you have the ability to study or review or ask for a
What would be
report.
your next step?
That would essentially be the next step.
Oh, and beyond that, I would say that we'd want a report that would tell us what our options are once we hear the reasoning. We're going to sit here and say, okay, thank you. And
Because
what can
Commissioner
we do?
Mnuchin is not here, and I think this is a very, very important issue, and thank you,
Let's take it up.
Mr. Dole, for bringing it up. I appreciate it. We could have missed this one very important issue. I think that we actually bring this up in the next meeting and have an actual discussion on this particular issue, and then come up with some kind of an agreement.
And I move to table it until
Table it until that time.
next meeting.
Okay,
Is that okay with you?
that's fine with me.
I don't want Commissioner Mnuchin not to be in this discussion. I think it won't be
Okay,
fair.
I would agree with that, provided we can get some sort of report when it comes up next time as to what our options are after we hear the reasons for not certifying one of the three on the list. I don't see how it's going to do us any good to hear the reasoning and then say, what do we do now?
Let me just understand, when is our next meeting?
It's in 2 weeks, March 14th.
Oh, that's good.
May I suggest that this come up when Ms. Barbetian, the reference by Ms. Barbetian as to the investigative powers
And
is
when would
also
that
ready?
be?
So that
Would March be too early? April?
March is tomorrow.
Yeah.
Yeah,
I'm talking about.
we
We
How
probably
about
need,
April,
yeah,
the
that would be
second
fine.
week in
We
April?
can bring it back in April.
Okay, so this particular item and the investigative power and our options, if the appointing authority decide not to do this, all will come on the first meeting in April, or the meeting in April.
Okay.
Is that okay with everyone? Does that serve your, what you wanted, Mr. Moine? Is that okay with you?
Yes, yes.
Okay, that knowing, then this is, we'll go ahead and leave this until first week in April.
So we go back to the 11 items that you had already discussed.
Yes.
We're looking for a motion and a second to approve those so that we may move forward with the meet and confer process as it relates to those. Yes?
If I could amend that, my proposal is that whomever is maintaining, I think the assistant city attorney is doing that, but our scriber has in fact kept the vote on those that we are pushing forward. There was one vote, certainly mine, I objected, but to move them forward, I would support a vote of this commission to move forward our work today with a report, incorporated report of the votes aye or nay with respect to each one of the items that were identified for discussion. I think that that's able to be done.
And certainly the minutes will reflect the ones where there was a vote that was approved by the 4 that are here? I'm assuming that the
No, it was
next...
4, it was 3 that are here, 1 is absent, and it was a nay.
No, I mean the ones,
time
the
he was
11, the collective, the majority of them that were
Oh, the one, yeah.
discussed. The minutes will reflect that, assuming this one also is approved. The other one is also approved, even though there was 1 no vote. So all 12 of them will move forward with the
Correct.
meet and confer process.
Correct.
But the
We need
minutes
to
will
vote on it.
reflect that
That's
there were
right.
2 different votes that were
Correct,
taken.
correct.
So we just need a vote on this one now.
Okay, I so move.
Anyone wants to second?
Second.
Move second, roll call, please.
Commissioner Gazarian?
Yes.
Commissioner McCarley?
Yes.
Commissioner Devine?
Yes.
Chair Abkarian?
Yes. What's next?
Mr. Chair, I would ask the Commission's indulgence for our, to have sufficient time to engage in the meet and confer.
Of course.
This is a lot of work. The law states that I must meet and confer with all 5 bargaining units individually. However, I would probably solicit a committee format if they would do so, but if they choose not to, then I would have to meet with them individually and go through these. So this is a process that I would anticipate taking a few months on top of additional work that I'm doing with our bargaining groups. We're negotiating with GFFA this spring, and there's just a lot going on. So,
Is June sufficient?
excuse me?
June
The
sufficient?
second week in June is when we are going to go ahead and schedule it, unless if you come in May and say that that's not sufficient time.
I will try for June.
Again, we're gonna schedule it for first meeting in June, unless if in May you come and say we haven't had sufficient time
It's
to
just-
negotiate with them.
Scheduling can be difficult, particularly when you're talking about
Go ahead.
cops and
Wait,
firefighters. and-
I'm an attorney, I need to have statute of limitations, so I need to have something that you shoot for. So first meeting in June, unless if you tell us otherwise in May.
Essentially, you're looking for a status report in May as well.
Yes.
Which report, I'm sorry?
Which
No, not a second. We want to have the report in June unless if in May, Mr. Dole said that he hasn't had sufficient time to finish them by June. So it's not a status report. We want it in June unless if we're told otherwise that we can't have it in June. Okay. What's next?
Let the record show Commissioner Manoukian has left. Reports?
Mr. Doyle?
Mr. Chair, members of the commission, all we have are the late performance evaluation report, which is a note and file, and looks like we've done some good work organizationally. We have 3 departments with late evaluations. The rest are all on time, so.
Okay, we'll discuss this later because we don't have time, but I can't understand if somebody's late 89 days, how could they be first notice? I just can't understand it. It just boggles my mind that somebody is late 89 days and it's still first notice. How could that even be? But anyways, we'll discuss this at some point in the next meeting, I'm assuming, because I'm assuming that there's some reason for it. Any other question? Okay. Anyone want to move to adjourn?
Move to adjourn.
Hold on. Any other comments by anyone? No? Move to adjourn.
Thank you, great chair.
We got through it, see?
Yes, thank you.